What if you just had a child? 4 steps that you absolutely need to take. I'm going to lead you through what these 4 steps are. First, if you just had a child, congratulations. What are the 4 critical steps that you have to take? Well, first, you have to be covered. You need to have your own estate plan. Do you have a living trust? Or if you have a very small estate, you're just getting started, maybe just a will, but really a living trust is what you need. Do you have durable powers of attorney for finance? Do you have advanced directives? Because if mom and dad aren't covered, the kids aren't covered. If you're incapacitated, who can step in to take care of medical or financial decisions for you? You need to make sure that you name people, again, in your living trust, power of attorney, advanced directive. Set that up. And if you haven't set it up yet, do it right now. If you already did it before you had a kid, you need to revisit it. Why? Because you need to make sure the kid's covered. So we need to look at how can you protect assets for your child, the ways you can leave assets in a way that they're not exposed to bad actors, to a dumb teenager, or other bad things, and to protect your child if they have special issues. So that's 2, protecting assets for your kid. You need to think through how are assets going to go to them. 3, you need guardian nominations. Of course, you need to think through who would you want to step in if you can't manage for your child, or if you're out of it, or if you pass away, who's going to step in and take care of your child? You need to think that through. Financial planning. We need to rethink your financial plan. Do you have the right plan? Have you thought about these issues? So again, the 4 key steps, you need to make sure your estate plan is up to date, your living trust, your durable power of attorney, your advanced directive. Because if mom and dad aren't covered, nobody's covered. How's your kid going to be taken care of if you're out of it?
You just have to keep in mind that if this kind of planning is done properly, it's not a matter of filling out a simple form, power of attorney. The heart and soul of what we do is counseling. It's really getting to know you and really knowing your individual circumstance. And I can't tell you how many times we have seen simple documents because the planner or the non-planner thought you were vanilla, and a plan was put together that was inappropriate, too simple, whatever, just not wrong for some reason. So even if you don't see us, you see an experienced attorney who understands these issues, and don't fall into this AI trap where it won't cost me anything. What could go wrong? Just a big caveat. We're increasingly worried about that.
And I think that's also important because a lot of our clients are really concerned. All of us are concerned about, is my job going to go away? Is my kid going to have a way of making a living if artificial intelligence takes over? Well, then you have to think about how you're going to protect assets for your kids and provide them with at least some financial safety net. We're going to some very uncertain and scary times. So protecting assets for the next generation. How do you protect assets for your child? Well, I think the very bare minimum would be an age restriction. So this is why we're not really big fans of very simplistic documents, because if you just have a document that says, hey, everything to my kids when I pass away, if they are over the age of 18, they're going to get all that money right away. No protections, no third party helping them, no smart advisor who has the right to say no if they want to make a bad decision. So the very least, you want to say, hey, look, if something happens to me before my child is 25 or 30 or 35, my assets will be overseen by a trustee. And maybe it's just your living trust extends after you're gone to make sure that your child's inheritance is overseen by someone, maybe with some money going out to them at different ages. And that's fine. That's better than nothing. Much, much more powerful would be taking steps to create a dynasty trust or a family protection trust. And you don't need to be ultra high net worth to do this. We have a separate webinar called What is a Dynasty Trust on this. And our version of dynasty trust are family protection trust. But here, you would not leave assets directly to your child. You would set up a family protection trust. If you have 2 kids, you'd set up 2 family protection trusts. There's 3 big other protections. So 1, if they ever get divorced in the future, assets you leave them are separate and not reachable in a divorce settlement if it's properly managed. If they inherit assets directly and commingle them, a huge chunk of what they inherit could be lost. 2, if they're sued, assets inherited directly, 0 protections. If it's in one of these trusts, there's a barrier. So nothing's 100%, but it's a very tough barrier to break through. So you're providing lawsuit protection and really powerfully state tax protection. So right now you can leave $12.92 million per person to the next generation without any estate taxes. And it's a big number, but we don't know what's going to happen in the future. 2026, it's set to drop by 50%, the exemption that's protected from estate taxes. Anything over that is taxed at 40%. In the future, the exemption could drop dramatically. We don't know what it'll hold, but keep in mind, if you leave assets in a protected way for your child, hopefully they'll grow during your child's life. A family protection trust can hold real estate, stock, mutual funds, and hopefully, even if it's used to support your child, it grows and grows and grows during their life. So depending on how much is in that trust, when your child passes away, it could be double or triple what you leave them. So you might think, I'm not leaving my kid that much. I have a house, that's it. $1 million or $2 million that goes to your child. Over time, they can grow 4 million, 6 million, 8 million. when they pass away, if it's in one of these trusts and they have kids, and it's where grandkids come in, it should be untouched by estate taxes. Whereas if it's directly to them, whatever estate tax laws are in 20, 30 years, who knows what they'll be, a huge chunk could be lost to estate tax exposure. Another issue, if you have a child or a grandchild, you just had a child and you know they have a disability, you need to create a special needs trust. Do not leave money directly to that child. Leave assets to a special needs trust. That is absolutely crucial. It's a way to protect that child and make sure a third party oversees the assets for that child, so no bad parties can manipulate them. And most importantly, the money in a special needs trust doesn't prevent them from getting needs-based government benefits like SSI or Medi-Cal. Now, I want to also talk about crummy trusts. So if you're higher net worth and you're worried about your own estate taxes down the road, there's a really cool way where every year, you may not know, there's a $17,000 annual exemption. It used to be $15,000. It goes up with inflation. You can give $17,000 a year to as many people as you want without even reporting it to the IRS. So for a married couple, it's $34,000 to as many people as you want. There's a nice tip right there. Don't even have to tell the IRS. There's no taxes owed, either for the person giving it or the person receiving it. You might want to do that for your child, especially if you have a larger estate. You want to start transferring money out of your estate if you're worried about taxes in the future. You could give it directly to your child, but then they get control of it when they're 18 or 19. Bad idea. How can you protect your child until they're 25 or 30? A crummy trust. It's a specially designed trust for the $17,000 annual exemption. It's a beautiful way to transfer money in a tax-free way for the benefit of your child without them getting access to it at the age of 18, which is a really bad idea in most cases. Of course, there's other financial planning issues we want to be aware of. You want to make sure that you've talked to your financial advisor. If you have a new child as well, you want to revisit your financial plan, but you also need to make sure that your beneficiary designations are up to date. So if you have a retirement plan, most of us have retirement plan through our work, or maybe you have life insurance. Maybe you didn't buy a separate policy, but you might have that through your employer. Well, if you have a child or a second child, you need to update your beneficiary designations as well. For retirement plans, life insurance, often people set those up when they're young. Maybe they name their spouse, and if their spouse isn't around, they name a sibling, and they forget to update it when they have a child. So you need to make sure that your beneficiary designations are up to date as well. If you just had a kid, remember, you need to set up your own plan. Think about how you're leaving assets for your child more than just directly to them. We need to revisit your financial plan, your beneficiary designations. And then, of course, we want to think about multi-generational planning issues as well. Take action. You can contact us. It's easy to find us, gilfix.com, 650-493-8070. You can join our large and growing client community. We serve people throughout the state of California, anywhere from San Diego to Wairika. And of course, subscribe to our Gilfix Law YouTube channel for more free legal educational videos. And if you have a comment or question, if you're watching this as a recording, leave that comment, leave that question. We'll try to get back to you.